Let's see. How loud is this volume? Chat, if you can respond. I just want to make sure that it's not too loud. Can't hear. Muted mate. Morning all from UK. Can't hear. You guys can probably hear me now because I'm just talking to my microphone. Good, perfect, wonderful. Okay, yes, Runkle woke up. I disturbed him from his slumber. He's awake. It's been a crazy past 24 hours. So let's do a brief overview of what we're going to try to accomplish here in the next few minutes / hour because, yeah, it's going to be a little bit wild. Runkle took a ton of notes. And as you guys know, when Runkle takes notes when he's in court, we do a Sleepy Runkle note and jury recap. And we have some fun with it. So, but before we do that, what we're going to do is walk through some of the basics of defamation, because I got a lot of questions in Twitter when I was kind of responding about the closing arguments and how some of the players, some of the attorneys made some pretty good arguments that I thought were meritorious. And the reason why I thought it and some of the pushback was essentially that how can these lies and statements that are falsities be the basis for recovery? So let's get right into that. So first of all, let's start with the premise that the U.S. system is different than a lot of other systems. A lot of systems that implement defamation laws, what they do is they start from the premise that speech itself is not technically permitted if it falls in a certain category. So they do a category distinguishing feature first. And they essentially dissect speech into various categories and they lump them in. They can automatically terminate or they can suppress certain speech that meets one of these criteria. The U.S. starts from a different premise. The U.S. starts from the premise that speech itself is inherently protected under the First Amendment. You can start with the assumption that speech, as you are speaking it, is protected unless someone can prove that it is part of a category of speech that is not protected. Certain speech is not protected under the Constitution. Categories are lies, defamatory statements, statements that incite violence, stuff like that. So the reason why this is important is that you start from this premise that the speech itself is inherently protected, and then that shifts the burden to the person who's contesting the speech, trying to quell the speech to prove that that speech itself is in a non-protected category, that speech itself is defamatory in nature or it is inciting violence, something of that type. And the principal case on the issue is a case that was decided in the U.S. Supreme Court in 1964, New York Times v. Sullivan. So we're going to walk through a brief synopsis of that case and kind of figure out where we get these criterion. So to do that, let me go ahead and do this. I'm going to share my screen so that you guys can see what I'm seeing in this moment. All right. So defamation. Right now, this is a state actor that's coming in and trying to suppress or limit speech that comes in. And we start, as we discussed earlier, the premise was that the First Amendment, Congress makes no laws that shall abridge any freedom of speech. So there's your premise. Premise is speech itself protected. Boom, done. There you go. Now you go into some of the things that, how do we classify whether it's not protected? New York Times v. Sullivan. So a background on this particular case. In 1960, civil rights advocates took out an advertisement in the New York Times, and the advertisement in question was taken out to oppose this man, Reverend Abernathy. And this was the ad that was taken out in the New York Times. I'll zoom in. Let me see here. This was the ad itself that ran in the New York Times that was the subject matter of the litigation in question. Heed the rising voices. Okay, so we have the ad. Basically, Mr. Sullivan was an elected official in Montgomery County, sued the civil rights leaders and the New York Times claiming that the police ringed a college campus and padlocked students in a campus dining hall in an attempt to starve the students into submission. They didn't dispute that the police never padlocked anyone. And the only students not given food were those who did not pre-register or apply for waivers. Okay. So the holding of this case essentially defined the outlines of how we analyze speech for defamation purposes. So essentially, when the government comes in and regulates speech, it's government action. So there has to be government action or first party action. In the case of a public official, which Mr. Sullivan was, or sorry, Mr. Abernathy was, you have to have clear and convincing evidence. The factual statement itself has to be false. There has to be malice. And malice is something that's been discussed in the Depp v. Heard case quite a bit. And this is kind of a good breakout point. So malice, as we understand it, common use of the word malicious, someone that's doing something to hurt somebody else for the purpose of hurting someone else. That's not really the legal definition. The legal definition of malice is that someone knew that what they were doing would cause the harm, and that knowing that, they went ahead and did it anyways. The second standard for that is that they should have known that it would cause a substantial harm, and they acted in reckless disregard for that knowledge. And that's important in the Depp v. Heard context, because that's kind of the standard we're looking at for the republication, the publication of certain things that are being said. Malicious in the Depp v. Heard case, kind of translating it, moving it forward to where we are now, is essentially that one of them had to know that the statement that was being made would hurt the other person. That's really kind of easy to prove in this case, because what they are alleging is SA, some form of assault, or DV, some form of a violent act. And if you're alleging that you were understandably a participant to it, or you were the recipient of it, and by being engaged in first person territory there, so you're either the actor or you are the recipient, then you would essentially know whether what you were saying, either that the SA or DV occurred, is either true or not. By having that knowledge and going out and saying something to the contrary, you have acted maliciously. I knew that what I'm saying occurred did not occur. Therefore, by me going out and saying that it did occur is me acting maliciously. Okay. So it's a pretty easy standard in the Depp v. Heard case. Let's fast forward a little bit here. Couple of important points. So, and in this, look, what we're looking at is basically a con law outline. It's an outline that we use to study these things, and they elaborate, or they kind of illustrate certain important information or the important elements of this. Okay. So standard defamation, the statement itself has to be provably false. You have to be able to demonstrate that as a matter of proof. Like, so essentially it has to be a fact. The sky is green. If I say the sky is green, that's something that can be proven false. The sky, Rob, is not green. The sky is blue, or the sky is gray. Okay. That makes it easy to understand that there is or is not a provable statement. This is important also in the context of Depp v. Heard, because the statement at issue in that case is that I was a victim of sexual violence. And by making that statement, you're kind of putting what that definition is: sexual violence. A provably false statement. Every element, every word in that sentence has to be something you can prove correct or prove incorrect. Go back to the example I gave you. The sky is green. The sky is blue. Easy to disprove that the sky is green, because you can look up and you can see the sky is blue. Take that and you move it to the area of the gray area. Domestic relations practitioner, we deal in the gray area. I was a victim of abuse. Abuse can mean several different things. Abuse can be physical. It can be mental. It can be psychological. It can be emotional. So to say that I was a victim of abuse, that encompasses a broad category, and it all turns on how we define that word abuse. And that's kind of where we find Amber's claim. Now, the nuance here is that the jury itself is posed with the question of defining what that word actually means. They have to determine that the statement itself is a factual statement that they can or someone can prove to be false. And in the context of Amber Heard, when she comes out and says, I was a victim of sexual violence, what that means is that the jury has to define what that term sexual violence means. They have to actually define whether the statement itself can be proven true or false based on the facts that they're presented with. And that's very important for this case because a lot of the allegations, as was relayed in closing statements and closing arguments today, were that, as Mr. Rottenborn relayed pretty emphatically, all you have to do is find one element. You have to find one allegation, one provable statement of abuse. And once you do that, then you've actually proven that that statement itself is not itself false. It's not a defamatory statement because there's an element of truth to it. Okay. The next element of this one is that the statement itself has to have the requisite sting. And this is language that the Supreme Court has been using for decades and decades and decades. The requisite sting, what that means is a statement itself, just because it's not true, doesn't make it defamatory. The statement has to hurt. It has to punish. It has to be penalizing. And this gets us to the second part of the Depp v. Heard case. Certain statements are deemed to be defamatory per se. What that means is they are defamatory just because they're said. There's a category of statements that by themselves the law recognizes as having the requisite sting. Among them are if you are saying that someone has a transmittable disease, that is a per se defamatory statement because it is recognized, commonplace knowledge, that if I say someone has a transmittable disease and that is false, that is defamatory. That takes us, that's the Cardi B case, where whomever said that Cardi B had some transmittable disease. That was not true. Cardi B proved it wasn't true, and the person kept on saying it. And that led to a lawsuit, and the person is now, I think, several $1 million judgment against them, which they're probably never going to pay off. But that's the second element of that one. In this particular case, one of the other things that is considered to be defamatory per se is when you allege that someone has committed a crime. By alleging someone is a criminal, if I'm saying they are in themselves a criminal, a felon, a batterer, something like that, that is per se defamatory. And that's the category that we're in here, where Amber Heard has alleged that Johnny Depp committed this act of sexual violence or abuse, and family abuse, as defined in the code, is a criminal act. So that then leads to the determination that allegation, if it's not true, is defamatory per se. What that does, once you've proven that an element, or once you've proven the statement itself is per se defamatory, you actually eliminate one of the other elements to the cause of action. Once you've proven that the statement itself is per se defamatory, transmittable disease, criminal act, then you don't have to prove that the statement itself actually caused you harm. It bypasses that other element. Now, if you're in the other category, let's say that I walk up and say, John Jacob Jingleheimer Schmidt, well, he's just a bad carpenter, or he is a bad person. I say that broadly. And let's say that he actually proves that that's not true. Well, that's not enough for him to recover. For him to recover, he has to prove that my statement actually caused him some element of harm. So he has to prove that by me saying that this person, John Jacob Jingleheimer Schmidt, I don't know why I chose that name, because I'm operating on like 3 hours of sleep over the past 24 hours. So we're going to go with it. John Jacob Jingleheimer Schmidt, he's a bad carpenter. Well, he has to prove that he lost a ton of business because of that improper statement. And he has to actually make a connection between the loss of business and the statement that I made. That's the element of damages. And when I say something per se defamatory, John Jacob Jingleheimer Schmidt is a thief, well, he doesn't have to prove damages, because it's implied that that statement itself is enough to actually cause him that requisite sting and to cause damages that he doesn't have to prove that element. Now, that's a nuanced answer, because the other thing is, yes, he doesn't have to prove the element of damages, but if he wants to recover, he has to give the jury some number to pin on. He has to give the jury some number that they can stick to, and he has to be able to prove that number. And in Johnny Depp's case and in Amber Heard's case, that's kind of the part of the case that's exceedingly lacking. They've thrown up numbers, $50 million, $100 million, and then they've put up experts to say, I can prove that they owe $50 million. And I think at this point in time, I'm going to bring in Runkle to kind of give an answer of how well the experts have testified to the demonstrable damages in this particular case.
Well, I mean, it really depends on which experts. There's been a whole bunch of different back and forth, and I mean, the jury could easily accept any of them or none of them, because there's been, for each of Depp and Heard, we've heard that they've lost absolutely everything or absolutely nothing. And it really depends on sort of which expert you're looking at. I think Depp's experts have been doing a better job overall in terms of actually establishing what they've been looking at. But I mean, ultimately, I suspect that a jury will find whichever experts to be sympathetic based on where they're already leaning. But a lot of this comes down to, it's very difficult for this sort of thing, because we're talking about people whose damages are going to be somewhat hard to quantify. We're talking about people who, a Hollywood star can go from everything to nothing overnight, sometimes for reasons that just aren't really clear. It's just people don't like them anymore. Uh, Actors fall out of fashion, and so it's not like if you've got a lawyer and they've been earning $100,000 every year, and then somebody makes a statement basically saying this lawyer steals from the trust funds, which is a real serious allegation, and I'm pretty sure would be defamation per se, in Virginia and wherever they've got that sort of rule. And then they can show, listen, my income went from 100,000 every year down to 50,000. That makes the damages really easy. You had a sort of predictable income. But there was a lot of argument back and forth as to whether or not did we expect Depp to work in Pirates 6? That's sort of an unclear aspect. Was Amber Heard's career going to explode because she got, Aquaman, which was the biggest movie ever, except not really? Or was she just not that great? And, her career wasn't going to explode because she's just, there's no chemistry, that sort of thing. So ultimately, I found Depp's experts to be more persuasive, that we had some sort of clear, some movies sort of clearly on the horizon. And I think Amber's case on the damages was undermined quite a bit, because we've got people like Mr. Hamada going, it has nothing to do with with Depp. It has to do with her just not being, nobody wants to watch your stuff, and we don't want to make it. So that, I think, it's going to be a big deal. But I also suspect, in terms of the damage awards that the jury actually gives, I mean, they're supposed to separate out sort of the actual damages from the punitive damages. But juries don't necessarily think that way. I mean, sometimes juries will think that the actual damages are higher if they're pissed off. So, if the jury thinks that, if they find defamation, but they don't think it was that bad, they may still think that Depp lost, movie roles and so forth, but still give him, $1. That is possible, right? Juries can do weird things, and as much as we tell them, hey, follow the law, that doesn't necessarily mean that they will. So yeah, I like Depp's experts overall, but Who knows where the jury's at? There was a lot of conflicting expert evidence there.
That's true. Well, and so that kind of brings me to another kind of one of these other principles in defamation law. So opinions, there is a distinction between something that is an opinion and something that is a factual assertion. So let me go back to that example of John Jacob Jingleheimer Schmidt is a bad carpenter. If I say that, there's two ways to view that statement. That could be an opinion or that could be a fact. And let me break that out and try to explain it in a better example. So John Jacob Jingleheimer Schmidt, let's say that I made the statement in a publication that he drove a nail through my foot. Okay. Well, if that's factually incorrect, then that would be an actionable statement because that's a factual statement. He did a thing that I can prove that is factually incorrect. But if I just make the statement that he's a bad carpenter, well, that starts teetering into the land of opinion. And the Constitution has always protected statements of opinion. And that also can kind of apply here to Depp v. Heard. If, let's say that Amber Heard makes this statement that says, Johnny Depp, well, no, look at the statement she actually did make, that 2 years ago, I was the subject to domestic or to sexual violence, and I saw Hollywood's wrath for it. Okay. Two ways to view that statement. One is in the context of this is Amber Heard's opinion and only her opinion, or this is a factual assertion. The only way you can sue on it is if it's a factual assertion. Now, Johnny Depp has already bypassed this. They've already actually succeeded in proving that this was a factual assertion. That essentially by making this statement, there was an implied fact that there had to have been an act of abuse in order for her to make the statement. So we've bypassed that one in this particular case, but that's something to keep in mind. Opinions themselves, if it's a pure opinion, Rob has bad hat. Rob chooses bad hats. I don't like the hats Rob chooses. That's an opinion. Can't sue on that. That's not defamatory. Now, there's also a carve out for public figures, individuals that are in the public eye. The reason why is that we've always viewed these individuals as essentially being higher. They essentially have to subject themselves to a little bit more scrutiny than the average Joe. If you have a president, say, for example, no, I'm not going to give an example. We're not going to get political with it. Let's say a president is very, very unpopular. And someone says, this president is an a-hole. That's an opinion. It's not a factual statement. You cannot actually factually prove that this person is an actual literal a-hole because a human is not an a-hole. But if you're making the statement, actually, that's kind of funny.
I'm just gonna snicker a little bit, but
I know Runkle. This is where tired Runkle starts making me laugh, and we both kind of go down this rabbit hole of having to prove that this person is not, in fact, an a-hole. And how do I do that? Do I do a doctor? Do I get a doctor up there and say this person is, in fact, an a-hole, or is not an a-hole? Yeah. Okay. Anyways, that's an opinion piece. So I can make that statement, and also I can make several statements about a public figure that are kind of quasi-opinion, quasi-factual. I mean, you see them in the mainstream media all the time, and this is what mainstream media hides behind a lot when they're sued for defamation. They basically say, "Look, we're giving commentary based on information that we have, secondhand information that we have gleaned from sources, and we made this statement. We believed it to be true, and it might not be entirely true." But this person's a public figure, and the individuals in the country have a right to know about the public figure. Okay. So for public figures, there's a heightened standard. You actually have to go above this whole, a statement was made and the statement was defamatory. You actually have to prove some element of intent. And that's where this actual malice standard comes in. So when a newspaper publishes something about a public figure, that newspaper, in order to be sued for defamation, has to have actual knowledge that the statement they just published was false. The best example of this one in recent memory is the Nicholas Sandmann case. Runkle, you know that case?
Afraid I don't. That'd be
So
a U.S.
this,
case, and
yeah, this is the guy that was where the Native American guy was beating the drum, and they caught the picture of him, and they said that there was a MAGA hatted kid who was taunting and maligning this Native
oh
American.
yes, yeah, that made it all over the news. Yep,
Yep,
that was
it
a
made it.
big deal.
It made it all over the news. It went everywhere. Now the problem is that this kid was just standing there, and he was wearing a MAGA hat. He was wearing a MAGA hat, and he was standing there. And this guy with the drum was the one that actually approached him, encountered him, confronted him, and started beating the drum in his face and started shouting all sorts of epithets to him. Now, the reason why this became defamatory was that the newspaper ran with the article, and they said that the kid was the provocateur. The kid was the person that caused all the strife. And the newspaper had all their sources on the ground, and they didn't check it. And had they just done one check, they would have determined that what they were reporting was false. Well, they went on mainstream media and blasted this kid, who I think was 18 or 19 at the time, and just slaughtered his reputation.
Oh yeah, there were people like calling for his head. There were people saying that he should never work, even at like a Burger King. It was that was a whole that was a nightmare situation for that kid.
Oh yeah. So that itself ended up being one of the only ones I can think of in recent history where you had a malicious or a malicious act by the journal, by the actual newspaper, that should have known that statement was false and came after the kid anyways. Okay. So that's the public figure exception to that doctrine. Let's bypass these things. These things are not really important for our purposes. And here we go. Let's go ahead and do this one. Okay, here's a brief summary chart. And what I'm going to do is this, and there we go. Okay, so in the case where there's no countersuit, if you have a public figure plaintiff that's suing a normal defendant, okay, the public figure plaintiff, someone that's in that public eye, what they have to prove when it's someone that's not in the public eye. So me, if I make a statement about some public figure, a senator, a baseball player, a professional NFL player, then that professional NFL player has to prove by clear and convincing evidence. And actually, this is a good segue here. So there's various standards of evidence, and among them, you have. There we go. There we go. This is a good grid. I like this grid. This is fun. There's beyond a reasonable doubt. And everyone in the chat probably knows with this one here. Beyond a reasonable doubt means that's the criminal standard that we use in the US. Essentially, you have to prove that this person, beyond any reasonable doubt, beyond any reasonable other explanation, did this thing that you are alleging they did. So it's not that you have to prove that they actually did it. It's that you have to prove that there's no doubt that this person has offered you that is reasonable for you to understand. So that's kind of a pretty simple thing. Then down here at the very end of the other spectrum, you've got reasonable suspicion. Basically, dude's doing something sketchy, and because he did something sketchy, I think he did something bad. Okay. Then you've got in the middle, preponderance of the evidence. And the way I always explain this one to clients is essentially if you ever see the Lady Justice and where she's holding the scales, right? And the scales tip a little bit that way, like one way versus the other. It's 51%. It's if there's 1 grain of sand on one side that's more than the grains on the other side, then the scales tip this way. That's preponderance. It's 50-50 plus 1%. That's preponderance. Clear and convincing is this middle standard between preponderance of the evidence and beyond a reasonable doubt. Now, the best way that I have found to explain this in lay terms is that the court or the jury is pretty damn sure that this occurred. So if you've got preponderance, which means that there's just a little bit more than 50-50, and you've got beyond a reasonable doubt, which means they're convinced. Then you've got this middle ground, clear and convincing, which means the jury's pretty damn sure. So that's the heightened standard that you have to prove in a public defamation case. So the plaintiff, the football player, has to prove, make it pretty damn sure that me, standard Joe Schmo, published the factual statement. Football player is a wife beater. That statement has the sting to that plaintiff's reputation. Calling a football player a wife beater, while some people in the chat might disagree, is something that has the requisite sting to a football player. That I had actual or constructive knowledge that that statement was false, that I actually knew, or that I should have known based on everything around me, that that was not a true statement. And then they have to prove that they actually incurred damages as a result of that statement. Okay. So that's essentially if there's a public figure, the plaintiff suing a defendant that's like a Joe Schmo like me. Okay. Now, there is a separate course, and this is where we find Johnny Depp and Amber Heard. They are both public figures. Sorry, they have both public figures, and they have both sued each other. So they both have to prove by clear and convincing evidence that the statements that each one of them made was a factual statement, that it had the requisite sting. So the requisite sting part of it in the Johnny Depp and Amber Heard case, that's out of it because they've both alleged that the other one is guilty of some criminal activity, that they had actual or constructive knowledge that the statement was false. This is where you get the whole, you either believe Johnny or you believe Amber, but you can't believe both of them because there was either an act of violence or not an act of violence. And if there wasn't an act of violence and it was just the two of them in the room, then they would know that the statement was either true or false, period. And then this is the other part here that's at issue in this case, the publication. This is a fun part. So publication, let me do this here. I'm going to see your face again. Publication itself. Publication is the actual statement itself. Publication doesn't really mean I have to run it in a newspaper. It doesn't mean that I have to put it on the TV. It just means that I have to put it out there in the open. It means that I have to say it out to a number of people where that person receives the information and they essentially interpret that information and it has a negative impact on this person's livelihood. In this case, you have two very, in the Depp v. Heard case, you have two very specific issues with publication. One of those issues is you have a statement that Amber Heard made in an op-ed that was published in the Washington Post. Now, a lot of people have asked, why is this lawsuit in Virginia? Why is it in Virginia? Why is it in Virginia? So many people. I'm going to answer that question, and hopefully you guys, enough people watching the video that I won't get it again. I probably will, but I'll answer it again. The reason why it's published here or the reason why the lawsuit is brought here in Virginia is that Washington Post is who ran the article. They are the ones who distributed that article. Amber Heard was the voice that acted through that body. And that body, when they distributed that article in Virginia. That's where WAPO's headquarters is. So that's where Amber Heard is said to have made the statement. That's where publication occurred, and that's where the damages are said to occur, and that's where the lawsuit gets brought. So that's why we're in Virginia. Publication. What does publication mean? It's easier in Amber Heard's case. It's a little more nuanced in Johnny Depp's case. In Amber Heard's case, publication is essentially that she put it out there. Now, there's two elements, or there's two parts that you prove this. One, the op-ed itself was published. It had her name on the tagline. She wrote it. It got sent out. Okay, good, done. If you don't have that, then how else do you prove that she published it? Well, there's this retweet, because for those of you who have watched the trial, there's two versions of that article that goes out. One of the versions is the print version, which does not have the headline, "I was a victim of sexual violence." The other one was the online that said, "I was a victim of sexual violence." Well, they need to tie Amber to that second version, the online version. And if they can't tie her to the online version, or if they can't tie her to the headline itself, then they lose that sexual violence part. The headline itself, Most headlines in op-eds are written by the newspaper. They write it because they need to maximize clicks, SEO, all the other stuff. So they're the ones that write it. So now Johnny Depp's team has to prove that Amber Heard somehow published that specific thing that was written by somebody else. Well, she can do that if she adopts it as her own statement and then sends it out anew. It's a republication. Every republication itself is itself a defamatory action. And they did that with the retweet. Now, there's case law in Virginia that says if you just retweet a hyperlink, if all I do is take a link and I put it into a chat or a tweet and I send the link with nothing else, then I have done nothing to actually republish that. All I have done is further the original publication. I haven't added it. I haven't republished it. In this particular case, if Amber Heard did anything to modify that tweet or to add to that tweet that was seen by the jury as having the intention of reaching a new audience, then that is republication for the purposes of defamation. And this is interesting because once you, Amber Heard, take a tweet, take the link, put it in your Twitter, and you type up a tweet and say, look at this article that I wrote, which is, I think, what she actually wrote in the tweet. Look at this article I wrote. And then you tweet it out to your new followers or to your other followers. You have directed them to this defamatory statement, and you have done so by actually adding to it. You have actually republished that statement. So that's the retweet. On the Johnny Depp side, publication is even more interesting because they try to use the attorney to do it. And Runkle, I need a sip of something in my, so I'm going to let you talk about the Johnny Depp republication.
So the republication aspect, basically there's this one tweet that talks about sexual violence. And the reason why this is such a complicated thing is that...
Ian.
Oh.
Johnny Depp. Depp's statement. His statements.
Oh, his...
Waldman.
Oh, yes. In terms of Waldman, you've got the issue of Waldman put out these statements, which of course are being denied. So that is... they're being denied as originating from Depp. So that is a bridge they have to cross on that one.
Well, so how do they cross it?
Well, what they're trying to do is they're trying to establish that he was acting as an agent. And, you know, an agency relationship is a relationship essentially where somebody is acting on your behalf and doing stuff on your behalf. So that is... that's an important sort of element there, because, you know, and you can think about this because you deal with agents all the time. And what is it? If you go and you renew your cell phone, then what you know, when you call up the person on the phone at your cell phone company and they say, hey, listen, your cell phone contract has expired. We'll send you a new cell phone in exchange for, you signing a 3-year contract, right? That person is acting as an agent for the cell phone company. They clearly don't own, you know, Verizon, but they are authorized to make those deals on behalf of Verizon as an agent. So that contract is still good as between you and, you know, Verizon. And you get, you know, all sorts of agency relationships which may have limits, like the Verizon cell phone, you know, call center person can agree to make can make that kind of deal, but they couldn't, for instance, sell you Verizon's, entire call center. They don't have, that kind of power. So that is that's kind of an important aspect. So what the jury is going to have to decide here in terms of Waldman is, were his statements, you know, in some fashion directed by Depp and therefore attributable to Depp, or, you know, or is it just Waldman doing his own thing? Because that's also a possibility, right? Just because you, just because of things there, you don't, just because somebody is acting as your agent doesn't necessarily mean that everything they do is, you know, acting or is in that capacity. the Verizon call center person, might then go and, when they get off work, they go and buy a sandwich. It doesn't mean Verizon is buying that sandwich. It's, and as a lawyer, you represent dozens or hundreds of clients. And yeah, so that is, that's a thing there. So
yeah, it's a bit of an issue. Okay, so here's what we're going to do now, because we've walked through the elements of defamation. And what I'm going to do now is I've got some super chats to read through. I'm going to read through those super chats, and then all of you guys, I have actually tagged this stream to feed right into Runkle's. And I know that you guys have been waiting desperately to hear Runkle give his breakdown of what he saw with the jury, because he is the jury whisperer. He knows what they are thinking and what they are doing. And the man is brilliant. Oh my gosh, we have someone to help with super chats.
Hello.
I'll talk with Mike. How's it going, big guy?
Good. How you doing? Third stream I've been on with you tonight.
I know. It's
Thanks
so
a lot for
much
coming
fun.
over to my channel. I appreciate it. It was fun watching Judge Simpson.
Oh, it's great. Runkle, you got to join on to one of Law Talk with Mike streams. We go through crazy like DUIs that make no sense, and then like sovereign citizen cases and people that are doing stupid stuff on like Zoom hearings. It's actually really funny.
Thank you.
Yeah.
I did one on the Queen of Canada. I wanted Runkle, but you guys were down there. I couldn't do it. But the sovereign citizen Queen of Canada was fantastic. All right, carry on.
Okay, so we just wrapped up basic defamation. We're going to hit some super chats, and what we're going to do is we're going to jump over to Runkle's stream, where he's going to give us his genius breakdown of the jury as he stares into his computer screen, which is what he is doing right now.
Right now, I'm trying to bring up. So I will bail out of this stream and jump into another, and hopefully everything will work out. So
yep,
there's
so
lots of people with lots of questions. We'll try to address those as we go.
Yep, Law Talk with Mike's going to help me figure out these. We're going to do the super chats, okay, buddy?
Fantastic.
All right, so let's rock. Let's see. Runkle CPAP machine fun. Yes, he was snoring very loudly in my house. He needs a CPAP machine. No, he doesn't. He was just very tired. He's gotten no sleep this week. Ben R got me to hose Muddy Middle and no money for either party. Elaine flooded the field with verbal diarrhea. Yeah, we kind of all had that consensus. Rottenborn's clothes was clean. It was pretty. And then Elaine came in there and muddied that thing up real quick. Win Depp Runkle is LawTube's hurtin' all Burton. That's pretty good. You know it's late when I'm laughing at that stuff. All right, Foxy. All right. Okay. Focus. No funny. All right. Foxy Crew. Why will proving defamation be difficult for JD? Because it's a very nuanced statement. The statement has to be factually disprovable. You actually have to be able to disprove the statement itself. The statement is, I was a victim of sexual violence and I suffered Hollywood's wrath. Sexual violence is a very broadly defined term, and in this particular case, the jury gets to define what that means, which makes it very difficult to prove one way or the other. Mike, any thoughts?
It does, but I think they did it.
You think they did? Okay.
Mm-hmm.
Donation towards sleeping chair for waiting. He's done waiting. He's done. He's done waiting for trials for a while. Love Sleepy Runkle. So do I. He's fantastic. Thank you for the generous super chat, by the way. Flying Monk Laura, thank you for waking up. Thank you for supporting us waking up, because I did not want to in that line. It was miserable. Thank you very much. Chima Lozano. So glad you're on. Was having withdrawals. I have withdrawals from sleep right now. But yes, thank you for joining. B555, Court TV showing 3 and 8 as alternates. Mistake. Yes, that's a mistake. Number 2 and 8 were dismissed. Unless Court TV has updated that within the last 30 minutes to an hour. If they have, someone better drop something in the chat to me, because I confirmed that through one of the attorneys. And if that's wrong, then I'm going to have some thoughts, because number 3 being off that jury changes a lot of my analysis. So if anyone has that real information, please drop that, because now I'm very curious. All right, ADHD, stop. Waking Runkle equals declaration of war versus Canada. Yes, it was. Yes, it was. It was a fight. U.S. won. Jackie Joe 15, $10. Thank you very much for the super chat. Be rational and nice when in this global sandbox. Kurt, uncivil, is a legal genius. Yes, he is. That man knows more about con law than I could ever hope to know.
He's a sharp guy.
Oh yeah. Found Amber's appeared doing due to judge mistake during jury instructions. Uncivil wins. Canadian Runkle is law tubes hurtin' Albertan. I like that. Hurtin' Albertan. We're just going to call that from now on. Were there any actual sanctions to Heard's team regarding not delivering the phones for forensic eval? I think those sanctions you saw ruled in evidentiary objections left, right, and center. Like there were things they were allowed to bring in and things they were not allowed to bring in and things they were allowed to testify to. And a lot of that was behind the scenes. So we didn't see it play out like you're not allowed to do this, because that would kind of suggest something to the jury. I don't know, Mike, did you have something else?
If evidence is barred, it's going to happen outside of the presence of the jury, and you're not going to hear about it, and that's the likely sanction.
Yep. Blurry Lights, would you clarify why the First Amendment ever was applied to a civil action between two parties, neither of which is the government? Because both parties have the right to speak. You both have that right to speak, and your right does not stop until it infringes upon the rights of somebody else. And that's defamation in its very nature. I have the right to say something, and I have the right to say that, period, end of story, until that infringes upon someone else's right to exist without my statement hurting them. Tammy, thank you for the super sticker. M Noodles, Runkle is my fantasy lawyer. Speculate on that. There's no speculation. He's my fantasy lawyer too. Nancy M, does the jury know nullification is an option? They do. They can basically say, neither of you get anything. See you later. Jenny Knowles, truth is truth. Yes, it is. Yes, it is. Kelly Ward, now that the juror instructions are in and the two jurors dismissed, what is your prediction on each defamatory statement and monetary amount? Thank you for everything. Mike, take this one.
I think they get SA. I think the monetary amount is low because they're not leaning for it. Amber gets nothing. I think the Depp win, low damages.
I'm leaning towards mutual dismissal.
Mm-hmm. That could happen too easily. I mean, but you have a better sense. All you need is one juror, and you got it hung.
Yeah, and that juror can hold out and say, "Look, I'm not going to grant one unless you dismiss the both."
Yeah, and you have much better sense than me because you sat right there and looked in their eyes.
We'll see. That information about from Court TV is going to be interesting, though, if that's correct. Mandy Lucas, did Elaine lower the defendant's amount from 100 to 350K? Missed the closing. Elaine basically admitted in closing that the 100 million was chosen arbitrarily. It was kind of funny. Alex B, Robin Ian, you two rock. Thank you. Ian does rock. I don't, but he does. Christina B, you guys rock. Ian does. I don't. We've established that. Proof of fact. Alan Deacon, would you be interested in doing a video comparing the UK test for defamation, how it differs, and how it may affect the outcome? I appreciate everything you've both been doing. I'm not going to read that part, but yes, the UK standard is very different than the US standard. I think it's kind of cool to dissect how both of them do. However, if you guys are interested, that was actually done in this particular case. If you go to the Fairfax County website, you look at high-profile cases and you search for opinions. There was an opinion that went through why the UK standard was different than the US standard and why the US standard was allowed to proceed. Jenny Knowles, he lost 2 movie roles because of her. That was testified to. Amber, no, which Amber are you? Because Amber Heard would not give me a.
I doubt she's a fan.
And she wouldn't give me $1.99. Well, she might give me $1.99. Oh, no.
Well, she'd pledge it to you.
She'd pledge it to me. Is this a pledge or is this a donation? The intuitive unshrink. Are you guys going to be trying to get in the courtroom next week for the verdict? No. So they released their rules for the verdict watch. You have to go and stand in line and get a wristband, just like we did with the crazy people, to go into a spare courtroom where nothing is happening and sit there and do nothing and watch nothing until the jury comes back and says we have a verdict, at which time Judge Ascarati clears her courtroom. Then you are escorted into her courtroom. They bring the jury in to read the verdict. I like reading verdicts. I like seeing verdicts. That's really cool to me. But standing in line for 12 hours, no, it's not worth it. Yeah. Surely Depp's attorneys had already thought of all this. They did, and they argued it. They did very good. Glenn F. I adore Runkle Rob bromance. Please stay out of cancel culture. I'm not all about this, guys. The cancel culture stuff, I'm out of it. Runkle and I had a great time today. We did well. So can you page Mike Hunt and Johnny Depp? Okay. I'm getting a note. I'm getting a note from Ian. Ian has reported to me to confirm. My note from Ian. Jurors 2 and 8 are out. 3 and 8 are not out. 2 and 8 are the ones that are gone. Can I page my cunt for Johnny Depp? No, I cannot do that for you. You would have to do that yourself, and I would recommend not doing that because
It's frowned
you know
upon.
what? It's going to get you in trouble. It really is. He has bodyguards. They're very big. They're very strong. You don't want to do that. That's muscle you don't want to handle. I'm telling you that right now. Okay. Jenny Knowles, thank you for the super sticker. Jordan, question. In the TMZ cabinet slamming video, did anyone pick up the notes stuck on Depp's back, stuck to his shirt, clearly visible? I'll take a look at that. Jenny Knowles, thank you for the super sticker. Megan Isaac, thank you very much. Love that you're watching. Makes me feel really good. Thank you very much. Sarah, Ian, can you explain the tweet? I'm going to make him do that on his stream. So jump over there. He's going to do it himself. Okay. Jenny Knowles, point being, his attorneys would have already known this. Yes, they would have. Correct. And they demonstrated that they did by their argument today. Mike, how do you think they did in their argument?
Who?
Depp's attorneys.
Fantastic. Very, very good.
Yeah, that rebuttal by Vasquez was.
Camille was the better of the two, but Ben did great too.
Yep, I agree with that. Saint Kate, credit to Law Lumber for the penknife discovery. Look, I'm not the first one to see that. I made a video of it because I kind of saw how the wood would work with that. And Vasquez drove that home. Hook, line, sinker, she got it. Grace J, op-ed context, push to reauthorize Violence Against Women Act, abuse meant to imply physical abuse. Why was this not argued? Because it's defamation. It's defamation, and what that means is the jury gets to define what the statement was and whether the statement was factual. Jenny Knowles, thank you again for the super sticker. Rochelle Summers, thank you for the super sticker. Jason Lazat, Rob, thank you for the explanation of the law and putting into terms non-lawyers can grasp. Do you have any plans on upcoming trials that you might cover? Keep up the great work. I actually might do a recap of the Lindbergh kidnapping.
That'd be cool.
There was a wood expert in that. They legit brought in a wood expert.
That plus there's always a ton coming up, but like you don't really know until they get near, unless you're focused on it all the time.
Yep. And it's honestly, it's a mess when you try to keep that focus. Mm-hmm. Cherry and Max, have you seen Uncivil Law tonight? I did. I was just on his channel.
He was on it with me. We were both on it.
We were going through those things.
We did have an interesting discussion about the verdict form. I do know what they're talking about. That was after you left. It does appear that there was some, instruction error at the very end.
Typo or something?
Verbal. From the judge. She was doing a really good job, but she just made a real quick slip at the end of the day. In terms of the jury instructions, it was confusing.
Okay. So we might get a clarifying question coming next week sometime. Mm-hmm. Zach Frisch, love the breakdown. Thank you very much. Elaine Elise, off topic. Does inciting violence mean literally saying go? So many discussions about it. You don't have to direct verbally to get the result you want, but how do you do proving that legally? That is a whole body of case law, like a massive body of case law of what is inciting violence. You could teach a full semester class on that, Mike. Yeah, it's not something I can digest in a video.
No, right. I get that because I'm sure you do too. People ask what are simple questions, and you're like, okay, that's a 74-page law review article answer. I get the question was simple, but it's not that easy.
And at the end of it, then you're going to have 50% of the experts saying one thing, 50% saying the other. Yep. Was clear and convincing explained to the jury, and do damages have to be financial? Yes, they did explain clear and convincing and what it means. The legal explanation is a lot more complicated than my explanation. My explanation is essentially half plus a grain of sand is preponderance. Beyond reasonable doubt, it's not 100%, but there's no other reasonable alternative. And then clear and convincing, which is the court is pretty damn sure. Mm-hmm. So I wish that they would rewrite the instruction to say clear and convincing is pretty damn sure.
Let's call it 51%. Clear and convincing is probably about 75%, and beyond a reasonable doubt is probably about 90%. I'm pulling those numbers out of the sky.
I like,
but
you
roughly
know what?
speaking.
I like that. That's good. I actually do. That's a pretty good. If you're doing percentages, pretty good. Danielle Peterson, can you and Ian quit your day job? Just make podcasts so I can listen to you guys all day long. That'd be a lot of fun. I just don't know that I'm good enough at that yet. FOM info, thank you for the super sticker. Is it common to steal juror information? Yes, it is very common. AH asked for it. Everyone asks for it. They don't want the juror information released. At least they want to give the jurors the option of making themselves publicly known if they so choose. That's up to them. They can still go out and talk to people if they want to.
It was sealed for a year, right?
Yeah, 12 months.
I think that's perfectly reasonable in this circumstance. It makes all sense.
Yeah. Abby K, question: if they could prove that his Twitter was only for professional use and not personal use, could that have been used to imply he acted as an agent, and vice versa with Team JD? I don't really think so, because to tie someone's speech to them, there has to be a very, very, very tight connection. Look, if I said Mike has access to my Twitter for a day, you're not going to be able to get me on defamation for something he says on my Twitter.
Yeah.
That's a pretty good way of explaining it.
Yeah, it really is. It's a good example.
Deja Blue Star, Rob, what can you tell us about what you guys thought about reading the jury, and if the two that were dismissed were for Johnny? I'm going to give a very brief one on this one, and I'm going to tell you to go over to Runkle, and you don't have to super chat, but just listen in. We're going to go over that there. Two that were dismissed, we both kind of had in our pro Johnny stance. Juror E concerns me. Like I said, go to Runkle's channel, follow him, see what we talk about there. Charlie Brown, if Johnny doesn't win, is it going to be sad for Dave for the male victims? DV, we're shamed to speak up. Kind of agree with that a little bit. Elena Elise, confused about Waldman. Why isn't it taken as a lawyer advocating for his client? Isn't that part of the job? You are not feeling dumb, and you are not dumb for thinking this. This is exactly the point that was argued, and I have a little bit of frustration that the issue was put to the jury in this way, because it kind of asked the jury to imply something or infer something in the relationship that might not exist. Miriam Gutierrez, thank you, Rob, for the explanation. You're awesome. Thank you very much. Grape flavor. Tips for my favorite law dudes. Thanks for Friday night special. It's Friday night. I'm operating on 3 hours sleep. We're gonna have fun. Emma Baby 902. Question: why the jury instructions sound like the court has accepted that Waldman is acting as an agent? It did not. It actually said the jury could infer that. They had to look at the evidence and determine whether that was or was not the case. So they're not forced to determine that. Jenny Knowles, thank you again. I don't get it. Your doors are stellar, but surely JD's attorneys were prepared. They were prepared. They did very well. I'm not saying anything about that. What I'm saying is that Rottenborn showed up in a way that I haven't seen him show up for this trial at any point in time since. So it was just a different version of attorney that I saw today. FC, why would your opinion change? Is 3, 8 are alternates? 2 and 8. Runkle just confirmed that. Imperfect creations. Do you agree? Guy should not have been let in? I am not going to even opine on that. Right. That is between him and the sheriffs. I was not a part of that. I have no part of that. Influence of Ariadna Jacob. I filed for defamation versus New York Times and Taylor Renz. Stressful how hard defamation is to win, how expensive and important experts are, especially knowing the New York Times has unlimited and New York Times claiming it is a licensed public person forum. I don't know.
I don't know what the acronym means.
Yeah. Suing any one of these entities is a massive uphill battle. They have entire legal teams that are dedicated to fighting defamation lawsuits. It is not, it is no joke. They really do. And the ones they hire are experts in defamation law, and defamation law is it's a First Amendment principle law, which means that there is 50 states worth of case law with all circuit case law, and you have to know all of it. It is really not easy.
And that's their stock in trade, and they publish things that irritate people literally every day. So they have to know this stuff cold.
Yep. Mary Ella Osborne. Orsburn, can the jury ask amount of legal fees incurred and use determining damages? Legal fees are set for a different hearing that's going to take place in August. Sid David, do you think Depp wins? Depp is representing us. I don't know. I'm not going to make a prediction. I really am not. I walked into this and I kind of was like 60%, 70%, maybe Depp. Those two juries getting stricken, and then Rottenborn's argument, I'm kind of in the 55 range. It's tough. It's not easy. This is a hard legal case, not factual case, hard legal case.
I'm really convinced, especially on the essay. She didn't.
You think so?
I think that they can demonstrate that's false. She had one bit of testimony that's absolutely unbelievable, and that's it.
And that's the cool part about having all of us on the panel is you guys get to see all the disagreement, and you get to see the rationale behind the disagreement, and it actually does really help. Mandy Rotary saw an article about the channel and the bed breaking video analysis on Facebook today. That was the LA Times article. That was pretty freaking cool. FOM Info, thank you for the super chat. Josephine Doors, thank you for the super sticker. Iris Gal, how did you feel when Camille leaked about bed knife today? In closing, made me wish you were an expert witness in the case. It just makes me feel good, honestly, that someone else sees the analysis the way I did. I have no doubt that she saw that herself. She was very bright in doing it, but it does make me feel good to be in that league of minds that like sees at the same time and sees the same things she did. So that makes me feel really, really happy. Beverly Alford, Andrea B said today to H is a serial attorney jumper. She never keeps the same counsel, likely because she's a client from hell. When she appeals this case, do you think she dumps Elaine and company? She will absolutely dump. If she appeals, she will appeal. It's going to happen. Just wait for it. It's not going to go anywhere because Judge Ascarati has done a great job at covering her ass. Don't worry about it. 920 Farmhouse. Is Ian planning to come back for another trial? I don't know. We got to find another one for Virginia for him. Annie McLaughlin. Question. Elaine said there's a tax advantage made by pledging to a charity. Is that true? Seems only once donations are given. I am not a tax attorney. Mike is not a tax attorney. I'm not going to opine on tax law. People get in trouble for opining on tax law.
But no, there's no tax advantage, by the way. He whatever, he has to pay it, so then it's reduction in his income. Or if he donated it, then it's a reduction in his income. He doesn't get it twice. There's no tax advantage. That part's true. That part's true. You don't get a double count. There's no double count. That's as far as I go. It's not deep, but it's a nonsense argument.
Yeah. Grumpy Bear, did Elaine have a stroke during her closing? It was bizarre. No, I think she just got word salad. Anne-Marie B, any thoughts on what is next after this case? Hello from Massachusetts. I'm going to start covering some trials of the century, and I'm going to get in the shop a little bit. I'm going to do some more fun work. I'm probably going to be on Law Talk with Mike a bunch, watching some funny videos, and we'll laugh together.
That would be awesome.
Make some stupid comments. Amber Heard. Oh, this is the real one. I couldn't take my eye off you. Call me sometime. Cool. Drop me a number, Amber Heard. I will not call you ever. Please don't ruin my life too. Jill Hertz, thank you for the super sticker. Very much appreciated. Glenn F, not sure why, but my super chat earlier was very generic and positive about you and Runkle, and yet it was cut off. Loving the AH and JD coverage. Glenn F, thank you very much. I really do appreciate all the support. And if you gave that generic super chat that was about Runkle and I'm going to give you double the love. I really do appreciate it. So does Runkle. That sleepy man is on a live stream right now, and I've got to go bail and save him. So I've got to work through these super chats because I can't leave him alone on a live stream because he'll never answer a question. What are Depp's options if he loses? Can he go back to court? No, he cannot. Court of Appeal is the only way to go. M Noodles, can you say hi to Mike Hunt? Hi, Mr. Hunt. Mike. Nice to meet you, Mike. Welcome.
Oh,
Mike,
thank you.
Look at that.
Thank
Mike
you.
is welcome. Mike is welcome on my channel anytime. Lauren Offerman. I think it was a patch on JD's search, not paper, or shirt, not paper. Good observation. Rurally retreated. Can you please explain the 51% to the now unanimous jury instruction? 51% is the weight of the evidence, not how the jury has to vote. The jury has to vote unanimously. They have to agree unanimously that there is at least 50% plus 1 grain of sand in favor of one person or the other. Tink Bell, thank you for the super chat. Antisocial, like the name. I'd like someone to compare this case with Roscoe Arbuckle case, escalating allegations of media sensationalism, ruined career even after the acquittal. I don't know that case. Mike,
I don't either. I do not.
I'm very sorry. I'm gonna have to look that one up though. Do me a favor, drop me a DM in Twitter and let me know. And because I kind of want to look up different stuff and compare. I like doing that stuff. I'm a ADHD kind of guy, so I do deep dives all the time.
If it's good, you can do a video on it.
Yeah, I mean that's there's all kinds of. Oh my gosh. Okay, we're going not backwards but forwards. Okay. Sid, Dave, Amber Heard will be on OnlyFans soon. I'm sure that some of the people in the chat would love that. I really don't want to see that. That's how she'll pay for money she owes Depp. Okay, that's how she's gonna do it. Good for her. Fierce Wiccan. Thank you all for taking your time to cover this. Thank you guys for actually supporting the coverage itself.
Seriously, we have taken a bunch of time, but I will tell you from our side, we all love it. So thank you.
Yeah, and yeah, thank you guys for giving us the ability to cover it, because the thing is, it also brings a lot of us together to do it, where we can actually, these panels, like, look, one attorney covering a trial is fun. 3 or 4 attorneys is freaking amazing, because you get a lot of input from a lot of people. Citizen Y, how big of a chance are you giving JD to win? 55%. That's what I said. And if you can expand on that, does Amber have an actual chance at getting money? No. At getting Johnny Depp's case dismissed? Kind of. Right?
I agree with that.
Matt Ricci, odds on if Amber will sue Elaine if she loses.
Yeah.
I don't know. But seeing those two in court together, yelling at each other. Why aren't they sequestered? Because sequestration is a way to lose a jury real effing quick. Not to mention, how are you going to sequester a jury? You're going to take their cell phones? Because if you do that, you're going to have a mutiny on your hands, and you're no way.
If you don't take phones, sequester means nothing.
Yeah, you can't do it these days.
I don't see any juries being sequestered anymore.
Neither do I. It's not possible.
It doesn't make sense in this day and age. It's like a bygone era thing.
Yeah, you're going to put them in a Faraday box? That's the only way.
Yep.
And Boyd, too sleepy to watch live, but wanted to say thank you for this. Saving to watch tomorrow. Oh my gosh, I'm so glad you're going to be watching this tomorrow when you're awake and live, and you're going to see us doing stupid stuff because it's late and we're tired. But I really hope you do enjoy this. Oh my gosh, I've got Kurt. Hey Kurt, how you doing? Great. We are blowing through super chats, and we're going to jump on Runkle's stream and keep him awake till God knows when.
Runkle said he's not streaming.
He's streaming right now. I can hear him downstairs.
Oh, okay. Did he send out a link?
I'm going to make him.
Not to you.
I'll pull it.
Damn.
We got a super chat about the issue with the jury instruction over here already.
Oh yeah, tell us about that.
You're making waves, Kurt.
Yeah. So I noticed a problem in the jury instructions, and I noticed also a defect in the judge's issuance of the instructions. The judge made a mistake when she issued the instructions.
Oh, what'd she say?
Thank you, Emily.
She said, okay, I'm going to get it wrong, but she said, if you find no on 1, 2, or 3, you don't have to proceed to 4 and 5. So the way she said it, she's like, if you find no on any of the charges, you don't have to go to damages. She said it backwards.
She made it sound like if you don't believe one of the statements, you don't have to go to damages on any of the statements.
Right. That's the way
yeah. It was obviously unintentional and just her going through it, but
right.
It's problematic.
And then the way the instruction is written in the instructions, I do not think is particularly clear into my mind, because the way it's written, it says, and I can put this on screen if you like, or not.
Share it.
Let me find it first.
Happy Chappy, I like the
We'll through why he's doing it though. He's trying to get through the super chat so he can go over to her uncle.
Okay, I'm sorry then. Never mind.
No,
don't apologize. Never apologize, Kurt. You beautiful man. Don't.
I apologize to my friends. I want them to be my friends.
We're gonna keep Runkle awake till like 3. He's going to be so mad. Makila Moray, I'm from Delaware, and it'd be cool if you could cover the murder of Anne Marie Fahey. Same thing I said to the other person. DM me that case, and I'll take a look at it and see what I can dig up. I get the verbal abuse argument, but AH cashed in publicly with false allegations of DVSA. For me, it lied under oath, and that's what determined AH is guilty of defamation, in my honest opinion. Not an attorney, just a survivor and humble registered nurse.
Solid analysis.
I mean, yeah, that's. I'm not disagreeing with you. This case is it's a cluster, and it's not a good one. Whose side do you think jury's on? I think they're kind of split. Like, I think there's probably 70% Johnny, 30% Amber. Influenced by Ariadna Jacob, limited purpose public favor, which I'm not. Best of luck to you. New York Times is an uphill battle, man. Amanda Lucero, how many days do you think it will take? Are you going Monday? I'm not going Monday. I have no desire to wait in that line again. I will see that come through. Hey, look, Kurt has 89,200 subs. That means that everyone who's in this chat right now needs to go to Uncivil Law and subscribe to him, please. And if you don't mind, please also go to Law Talk with Mike and subscribe.
Well, thank you
To him as well. I'm going to be spending a lot more time on both of these gentlemen's channels in the coming weeks as I start making more content that's behind the scenes. JP Farquetura? Sure. How come AH testified under oath about pictures 712 and 713 being two different exhibits? Because she maybe didn't tell the truth. I think that's the best way to summarize that. Shauna. AH attorneys used the "if you can't dazzle them with brilliance, baffle them with BS." Yes, that was Elaine's closing to sum it up pretty accurately. Please tell me you've seen the TMZ video 8/16/16 stating Amber leaked the video. I have not. I honestly haven't had time. Patricia Mazzini, wow, my two favorite lawyers from Law Tube together in night stream. Yeah, I'm very glad that your three favorite lawyers are right here on the stream right now. Kurt, me, and Law Talk with Mike. Sorry, legal fees are a set case already. Yes, legal fees were bifurcated from this action because they are actually you're entitled to them under the anti-slap defense. So they are bifurcated. They're going to be heard in August as a separate hearing. They're going to challenge the reasonableness of the fees. They will likely have experts going through all of the invoices because this is a multi-million-dollar legal fee case. You are not going to want to watch that hearing. It's going to be a freaking nightmare. And
right.
Yeah, exactly. Guys, we're going in the wrong direction here.
There's a good chance all that resolves based on the verdict too.
To all the Canadians still in the chat, Runkle confessed to me he's not a hockey fan. I just outed him big time. Carolee 501, was the definition of malice in closing incorrectly stated? No, it wasn't. It's just not. The definition of malice, legal definition of malice, kind of sucks. It doesn't really give the standard juror the actual understanding of what malice means. It's really hard.
In closing, it was because Elaine misstated it.
Well, Elaine misstates a lot of things and misrepresents a lot of facts. I'm late asking, but how exactly are experts disqualified? I've worked doing analysis of Twitter, Insta, data, and Chanel frustrated me. Unsure how he's permitted to testify for so wrong. It is not easy to disqualify an expert. You basically have an expert to disqualify that expert. It's a pain in the butt. Basically, if their credentials add up, they can testify as an expert, and then you get to impeach them and go after them and say that you're an idiot. It's just not that easy. Tashara Angel, question: if Amber loses and tries to appeal, can she still say that JD isn't leaving her alone? No, appeal is going to be based on the record at this trial right now. 9001. Can Johnny still sue the Washington Post if he wins? Nope. Statute of limitations passed. ADHD. Will you marry me? No, thank you. I mean, thank you for the offer, but no. Guess who? Did you see Amber Turd snort something on stand? I don't know what she did on the stand. It was weird. Money,
but who knows?
Yeah, it was awkward. It was uncomfortable. Money Batala, I'm late, but was jury I pro Depp taken off? I is still on there, and he's a savage.
Was the note taker taken off?
Note taker still on there.
Okay,
he was
cool.
A and 1. Yeah, A and 1 is still on there. And F, I think F is the young Caucasian male. He's going to be our foreman. I have a $20 bet with Joe on that one. Sid Dave, is AH not required to prove all her claims? Can jury still give verdict on her behalf if it's clear she lied on some claims? A jury can do whatever they want right now. I hate to say it that way, but they kind of can.
Mm-hmm.
They're likely not to, but they can. Megan Sue, I felt personally attacked by Elaine watching on YouTube. Was this how the jurors reacted? I really want to know how the jury reacted. They did not react that way. They really didn't give Elaine much of anything one way or the other. Honestly, when she first started talking, they were smiling at her because she came in with that joke of, I get to say good afternoon to you. And they actually smiled. It was the first time I've seen them react that way to her the entire trial. Happy Chappy would Rob would have literally come out of the woodwork if he did testify. I probably would. I don't know what wood I would have come out of if I would have testified. Shirt, sweat to I don't know. I have learned so much about the law the past few weeks. Thanks for all the knowledge to all the lawyers. All of the lawyers add a ton to all of these panels. Go subscribe to all of them.
I learn a lot.
Actually, yeah, we all do.
I'm on these panels and I'm just listening to other people on the panel. And I'm learning a ton.
I mean, I think the chat would have benefited if Kurt was here for the description of New York Times v. Sullivan, because I'm guaranteeing you that man knows more about that case than I could remember in a given day, any day.
I know all the things.
Yes, he does. So go subscribe.
Did you know it's impossible under New York Times versus Sullivan to defame the government?
I did not, but now I do.
There you go.
Okay. We learned something. Okay.
I have other constitutional law cases I can talk about.
You have a million, dude. Con law that's you.
Let's talk about the horror show that is Buck v. Bell. Okay.
No, we're not going con law right now. I can't do that. My brain can't process it. Terry Zelensky, interesting point raised on civil was that if the jury asked for clarifications on damages question, then people will know they found on first of the three elements.
Oh, yeah.
Interesting point, Kurt. That's interesting.
Yes.
Oh, shit. That's pretty cool. I'm going to keep an eye out for that one. The notion I got from closing argument was pretty much scaling rhetoric from AH sides. Scathing, I imagine that was supposed to say. I like the judge. She's very good. Hi, Rob. No, I'm not going to give you that. The ASL. I think I know what that means. I'm not going to give you that. Isabel Sanchez. Hey, Rob. Don't see Amber getting any money, but I'm not sure about Johnny. Hope his evidence is good enough for the jurors. Can't wait for the verdict. We will be waiting for a few days. Mr. Hunt, Michael, loves my channel. Danielle Johnson, my hub was sequestered for a week, and a couple years ago in New Orleans, it was awful. We just had a baby. I can't see how you can do it now. Even a couple of years ago would be easier than doing it right now. I think sequestering a jury right now is quite literally stabbing your own case in the throat. Like, it's just, there's no way. You guys are awesome. I slept and waked up to you guys. That's motivated. Was there a verdict? That's actually a bad thing for us, because that means that we did not sleep and we were awake when you went to sleep and were awake when you woke up. We shall see about the verdict. How much sleep have you gotten, Rob? 3 hours in the last 36. Influences by Ariadna Jacob. Elon Musk just tweeted about JDAH. I hope they both move on. At their best, they are each incredible. Good for Elon Musk. Josh Pickhole, honest opinion about the face in the court. No drama, just clarification. You guys are great. I'm not going to get into that. The judge had an order out there. That order was what it was. So you guys can look that up. You can make your inferences. I'm not getting into it. Tom McGinnis, Camille needs nominating for the lawyer's version of the Oscars. Elaine for the Razzies. Kind of agree with that one. You guys are Mr. Hunt, Mike's favorite. I think this case will prove a lot if Amber has to win. What would people really think about the justice system? I don't know. I think that this is part of the media problem here, because there's a way that Amber wins, and there's a way that the legal system still has a great deal of integrity. I just think that the media coverage on this case has kind of screwed us in that regard. Guys have thoughts?
No.
Well, people think this on every case. Any case that they pay attention to, they think is a referendum on the legal system. What they're not aware of is that these cases are being decided absolutely every day, all the time.
Yep. Citizen Y, can anyone charge Amber with perjury? I think the UK is. I'm hearing rumors that they're trying.
Yep.
They
have some motivation to save face.
They kind of do, especially if the jury comes back for Johnny, they're going to have more motivation to save face.
Mm-hmm.
Ooh, that's going to be spicy. Chono Dakeen, if the jury given anyone to translate jury instructions, understand arguments, and spot inaccuracies they witnessed in the trial while deliberating. No, they have to digest it as normal humans. M Noodles, why you keep talking about Hunt, Mr. Mike? I don't know. You keep asking about Mr. Mike. Our tribe of 5.
Just
Thank you
that
for the super
immature.
chat. What would your reaction be if AH wins, even after we heard all the lies? I would honestly hope that the jury reached the decision based on an application of defamation law and not the factual basis for her claims. I think that's kind of the best way I can describe it.
Mm-hmm.
Ann Richards, if the jury has questions, will that be televised or is it more informal? We actually don't know the answer to that question. So
No,
I actually can look that one up.
If the jurors have questions now, they send a note to the judge, and then the judge will contact the attorneys and say, "Hey, they're asking this," but that's all backdoor. No, you're not going to even hear about it.
Yeah, Ask Rod is going to be like, I'm going to send them this. Say no if you want me to send something different, and if you say no, I'm going to ignore it.
Mm-hmm.
Short, sweet, to the point, no vowels. I'm pushing 5 feet tall and have a great right hook. Dude, awesome explanation for the name. Thank you very much. Yeah, good point. Megan's 2819. If you were JD, what of these attorneys would you want on your team? You can mix and match between the two. What's your dream team out of these attorneys? Oh, this is going to the panel. What do you think?
Vasquez for days.
Yeah. Who else?
I just
can Vasquez be all 3?
Yeah.
Vasquez all 3? Rottenborn didn't move the scales for
Rottenborn's my only pick from the herd team to even for consideration.
To even consider, yeah.
Mm-hmm.
Okay.
But
Rottenborn, Vasquez, those two on a case, that's deadly.
Rottenborn, Vasquez, I like Benchu a lot too.
I do too. You have the soft Benchu, you have the aggressive Vasquez, and you have the arguing open and close with Rottenborn.
Yeah.
That's lethal.
That's a good team.
Yeah, I'll take that any day. Have you decided on a different logo, Kurt stream yet? Yes, still have that. I have to make stuff. I need this trial to be done. This trial is almost done. As soon as verdict's done, I'm making stuff, sending stuff out. Yes. First off, thank you for all the content, for all you guys do. Curious how it might work for a visually impaired juror. Would they choose one? Does the court have screen readers? Actually, yes. This is an interesting topic, and jurors cannot be screened out simply because they have a disability. The disability has to have an impact on their ability to assess the case as a normal person in the community. There is a juror that was on this panel who has, I'm not going to say it. There was a juror on this panel who we believe had a hearing disability, and there were hearing assisted monitors that he had that he would use when he needed to. So it was, you don't get screened out immediately because of a disability. Everyone take a drink. Every time Rob talks about Hunt, Mr. Mike.
It never ends. Oh, it never ends.
Chad Hibbs, do you post any of the lumber side of Law and Lumber anywhere? Fellow woodworker here. I actually might start a separate channel to start posting dedicated woodworking stuff and kind of feed both channels a little bit so that I'm not muddying one channel so that people can see content that they want to see. It's a lot of work though.
It is a lot of work, and when you're splitting your channels, you're splitting your focus. I don't know, but then again, you have way more subs than me, so who might give you advice?
I don't know what to do, Kurt. I right now my brain is fried. Can AH be charged with perjury? I think UK is thinking about it. Elon thinks Amber's incredible. Her next target. He's her next target. She already got quite a bit of money out of him. Catherine Kennedy, thank you for the super chat. Average Joe, do family lawyers maximize what they can get? Not the good ones. The good ones actually do it for the right reason to make sure that the family is still intact and actually decent. Grab my passport, turn off super chats, and go rescue Ian. He needs a Red Bull. Yes. Okay. I would love to. I have 2 more to read. Family lawyers maximize what they can get. No, they do not. Okay. Gosh, Chris, all right, tell me. Okay. If H loses and has to pay JD $50 million, how much time is she going to pay? That's going to be she's going to have to fight that in court as they're trying to collect it. Hunt, Mr. Mike, and Mike, Oxmal, Mr. Mike.
Had to.
Oh, Law Patrol, you have been appearing in chats, various places, and disrupting chats. Hunt Mike and Oxmal Mike should go get a coffee. Okay. All right. A minute of broadcast. Everyone, Ian's chat should be in the stream right ahead of you. Thank you very much for the super chat. You guys, I don't know what to do.
Send me a link. Send me a link so I can join his chat.
Yeah.
Yes.
Send on links if you feel like it, but go rescue the man.
Yep. I'm going to go save him and send stuff over to you guys.
Thank you all. Nice to see you.
All right.
Thanks, Rob.
All right. Love you guys. Talk to you later. Bye.